Constitution, Article 368 to be exact, their experience and also based on their history generally. Therefore, in relying on Casavananda, similar to Article 368 of the Indian Constitution, in the sense that the power to amend the Constitution reposed in Parliament and Parliament alone. But this is no longer the case in Kenya. Throughout the constitution-making process, from the Bomas draft, the Wako draft, the revised harmonized draft, and the proposed draft constitution, it has been made abundantly clear that since the Constitution embodies the will and aspirations of the people, they must be central to its amendment, and that there ought to be a balance. To have a constitution was achieved by clear, unambiguous, and distinct tiered or multi-stage design model, codified in Chapter 16, applying different procedures of amendment for different provisions of the Constitution. Specifically, amendment process of any matters in Article 255(1) is complex and onerous. It requires support of 1 million voters, requires the promoters to draft a bill, which then must be verified by the IEBC, and finally, and approval by the county assemblies and parliament, meeting a certain threshold, and finally ratified in a referendum. Attempts to utilize both parliamentary and popular initiatives have failed, essentially because of the tiered or multi-stage design of Chapter 16. You remember the Okoa Kenya Bill 2016, Punguza Mizigo Bill of 2019. To this extent, even the two courts below agree that Article 255(1) embodies the basic structure of the Constitution of Kenya. For me, the most difficult part of the two judgments of the two courts below, and the dilemma flowing from them, is the imprecise scope and extent of basic structure. What does it mean, for instance, when the High Court and the Court of Appeal accept must provide pragmatic solutions without adding confusion to the controversy that the parties have brought to them for resolution in the first place? Amending the Constitution is not a light matter, therefore, limitations to its amendment must sufficiently be specific and unambiguous. In India today, because of the nebulous nature of implied limitations to constitutional amendment since Casavananda case, every court has attempted to identify by listing some of the essential structural elements of the Constitution that in their individual perceptions constitute the basic structure of the Indian Constitution on a case-to-case basis. Chapter 16 exhaustively sets out the process of initiating an amendment to the protected provisions. Of course, that process includes public participation and a referendum. That is in answer to the question of where is the juridical basis in the Kenyan context for the proposition by the two courts that the basic structure of the Constitution can only be amended through primary constituent power, which must include four sequential processes, namely civic education, public participation, and coalition of views, constituent assembly, a debate, and ultimately a referendum. The last matter under this ground is to consider the unanimous conclusion by both superior courts below that the proposed amendments in the draft bill to, and I quote, shake the foundation law in the Constitution and making, replacing, disassemble, completely change identity, abolish, tear apart, amputate, and rough mutilation. Do the proposals in the amendment draft completely change identity, abolish, tear apart, amputate, employed by the learned judges to describe the proposals in the bill and to suggest that the proposals were a dismemberment of the Constitution. Are they so? In my most respectful view, these words were an overkill, and the sledgehammer employed to deal with them was in itself disproportionate. I end this ground where I started. However great, however progressive a written constitution may be, history, experiences, and changes in society would necessitate corresponding changes to the written text of the Constitution, with each generation having the right and freedom to determine the law under which they wish to live. And no generation should bind the course, aspirations, constitutional expectations, values, principles, and objects of generations to come. The language of Chapter 16 is clear and plain, leaving no room for conjecture, inference, or implication. Neither the explicit nor the implicit language of the Constitution, the history of constitutional making, or any principle of constitutional interpretation in this country permits the courts to do what the courts have accused previous parliaments of perpetuating, that is, to undertake indiscriminate and radical amendments to the Constitution by imposing an alien that to the extent that the basic structure doctrine are the real norms of this dispute. This particular question seeks to answer the issue of legality, legitimacy, and constitutionality of the process leading to the formulation of the draft bill based on the true construction of Article 257. The High Court was persuaded and declared that the President does not have authority under the Constitution to initiate changes by way of amendment that are by Parliament through parliamentary initiative under Article 256 or by a popular initiative. Friday afternoon, March 9th, 2018, which was the same day the justices of the Court of Appeal elected me as their president at Safari Park Hotel, will be remembered as one of the many defining moments in the history of Kenya. It was on that day that in a advisory by a subsequent special gazette notice of 10th January 2020, published, and as the name suggests, to implement the report of the task force of the Secretariat, whose origin is not clear to me, since I have not been able to trace on record any appointment letter or a gazette notice, appears on the scene. So, co-chaired by Honorable Dennis Waweru, a former member of Parliament for Dagoretti South, representing the people of Suna International Conference Center, the President launched the draft bill and rolled out the collection of signatures to support the initiative. A popular is commenced at least 1 million registered voters to support it. It is the promoters who must formulate the draft bill. They are required thereafter to deliver the bill, and supporting signatures to appeal are unanimous that the term popular initiative can only be an initiative by the general public. Chief Justice in Githunguri as the man in the market, the man on Pangani bus. On the other hand, the word promoters in the Constitution is used only in Article 157. It is apparently a term of art in the context of amendment of the Constitution, describing the persons not in the company law sense or in the colloquial sense, but those who initiate or champion constitutional changes. Beside the definition of the term popular initiative, there is history behind necessary for the people, in bracket, citizens and civil society in exercise of their constituent power of Article 257. It is the people. They suggest first the Secretariat. However, Honorable Waweru himself, on behalf of himself and the co-chairperson, swore an affidavit of 5th February 2021 to state that the Building Bridges to a United Kenya was created and action of views and proposals in various fields affecting cannot be conceived. The affidavit says it all. The great-grandfather is the handshake. The grandfather is the task force. Its father is the steering committee. The bill which the Secretariat presented together with the signatures to the IEBC was clearly, so to speak, inherited from the steering committee, almost a replica of the bill annexed to the steering committee's report to the President. The draft bill was curiously signed by Building Bridges Initiative as the promoters, and not Honorable Waweru or Honorable Junet, or even the Secretariat. It's not clear how they went about collecting the signatures, but on record, at least, there is some evidence of state involvement, going by the letter written by the Principal Secretary, State Department for Sports, directing the Director General, Sports Kenya, to supervise the staff in the organization. The conclusion I reach, as should be apparent on the first limb of this ground, is that the President, as a matter of fact, commenced and spearheaded the process from its inception and only passed on the baton to the two co-chairpersons when it was too late in the day and beyond recall. That the President is ineligible to directly or indirectly initiate a constitutional amendment to the Constitution under any of the prescribed circumstances. That he cannot act as an ordinary citizen because he is not, and at the same time claim to be exercising executive authority. He cannot, in the circumstances of Chapter 16, run with the hare and hunt with the hounds. It has been argued that by barring the President from initiating the process of constitutional amendment, his right to equality and freedom from discrimination would be violated. The nature of violation has not been demonstrated. Looking at the facets of the rights and fundamental freedoms under Article 27, I cannot see any that could be breached by simply asking the President to stay on his lane of constitutional amendment process. Similarly, the guarantee of his political rights, which are specific under Article 38(1), that is to make political choices, to be registered as a voter, and to vote by secret ballot in any election or referenda, have not been violated. The President's role in the constitutional review process has been preserved and is intact. The power to assent